Okay, thank you. Looks like we have all of our justices present, as well as counsel for the next case, No Boundary versus Cornell Hoosman. Let's do a quick sound check. I will start with Mr. Augustine. Can you hear me? And I'd like to hear you.
Yes, I can hear you, Your Honor.
Thank you. Thank you. And I'll next move to Mr. Schmidt. Can you hear me? And I'd like to hear you.
Yes, I can hear you, Your Honor.
Thank you. And we will begin with the applicant, Mr. Hoosman, for Hoosman. Thank you.
May it please the court. My name is Todd Schmidt. I represent the appellant in this case, Cornell Hoosman, and it's a privilege to be here. This case is about a man with serious cognitive impairments who risks losing his home, over $220 in unpaid property taxes, and who's never had a meaningful opportunity to be heard or defend himself. Mr. Hoosman is a person with disabilities. His disabilities prevent him working. He receives $771 each month in federal disability benefits, and he owns his own home. And sometime after he acquired his home, he suffered a brain injury and underwent intracranial surgery in 2012. The following year, in 2013, Mr. Hoosman was found incompetent to stand trial in a criminal case. And again, in 2016, he was found incompetent to stand trial due to his disabilities. During this period, in 2014, Mr. Hoosman failed to pay his property taxes. Those property taxes were sold at a tax sale in 2016. And on November 30th, 2018, the Black Hawk County Treasurer executed a tax deed. The plaintiff filed this removal action, and Mr. Hoosman failed to respond to the lawsuit, and a default judgment was entered. Now, there's no property interest more sacred than a person's right to their homestead. And it's a long-held principle in Iowa that the statutory right of redemption should be liberally construed in favor of the taxpayer. Iowa law provides special protections for its most vulnerable citizens. The general rule is that property can be redeemed up to the point in which the tax deed is executed, but Iowa Code Chapter 447.7 provides that a person with a legal disability in possession of the parcel can raise the right to redeem in a removal action as a counterclaim. My client, Mr. Hoosman.
This is Justice McDonald. I have a question for you about the state of the record and what was presented to the district court at the time of the hearing on the motion to set aside. What evidence was presented to the district court about whether Mr. Hoosman was suffering from a, quote, legal disability in terms of the meaning of the statute?
Thank you, Justice McDonald. Mr. Hoosman retained Iowa legal aid, and an Iowa legal aid attorney filed a motion to set aside the day before the writ of removal was set to be executed. In that motion, the attorney cited the two criminal cases in which Mr. Hoosman was found incompetent. And then the next morning, Mr. Hoosman's attorney appeared with Mr. Hoosman personally at order hour. They were prepared to present medical evidence, the 2013 competency evaluation, and Mr. Hoosman was prepared to testify about his disabilities. But the trial court refused to hear Mr. Hoosman or take any evidence and issued a summary denial of the motion with no findings of fact.
Can I ask you to, so I understand there was a 19042 motion filed to reconsider, and I think it had the competency evaluation attached to it with a statement that the district court didn't receive the evaluation. Where in the record does it indicate that Mr. Hoosman was prepared to testify and the district court didn't allow a hearing or didn't allow him to testify or put on other evidence?
Well, Your Honor, I believe that the trial court's order does state that the defendant, Mr. Hoosman, appeared personally with counsel, and that the court, does that answer your question? The court heard?
No, because I think it says that, I mean, it's pretty clear that evidence was not received by the district court, but it wasn't clear to me anywhere in the record that Mr. Hoosman was offering any evidence other than the competency evaluation. And your statement went directly to my concern is, I would have assumed that if he was there, he and his lawyer would have said, Your Honor, we'd like to make a record. We'd like to put on some evidence, some testimony, etc. And I guess I don't see that anywhere in the record. So help me out with that issue.
Well, Mr. Hoosman tried to make a record. He was present and asked to make a record, and the court would not make a record. And so certainly, a 1.904 motion, the purpose of a 1.9042 motion is to enlarge an existing record. And, it's not an instrument to relitigate issues addressed at trial. But here, Mr. Hoosman never had an opportunity to go to trial or have any type of a hearing. So, in this case, he attempted to submit it at the time that he presented to the court. And then he attempted to submit it with the 1.904. And I would say that both of those attempts were comparable to an offer of proof. He attempted to enter the 2013 competency evaluation into the record. He was prepared to do that, and the court would not allow him to submit it at the time of the hearing, and that evidence should have been considered in the court.
So you're referring, this is Ed Mansfield, Mr. Schmidt, you're referring to paragraph 4 of the 19042 motion, where it was stated that Mr. Hoosman was present at the hearing and there was an effort to offer medical evidence and it was not received by the judge. That's what you're talking about?
Yes, Your Honor. Thank you.
And was that other evidence something in addition to the competency evaluation that was attached to the motion?
The evidence that he was prepared to submit was the competency evaluation that was attached to the motion.
Thank you.
Well, Counsel, is the relief you're seeking to vacate the default? I'm wondering if a step short of that should be remand for the district court to allow a evidentiary hearing on your motion to set aside.
Your Honor, Mr. Hoosman is requesting a reversal, and he is requesting that he be allowed to file a counterclaim in this case pursuant to 447.7. If I think there is certainly enough in the motion that the trial court could have granted the motion. However, the trial court does have a lot of discretion in terms of how to evaluate a motion to set aside. And really the abuse of discretion here, if the trial court had concerns about whether he was still someone that was under a legal disability, then the trial court should have taken evidence in this case to evaluate that. So in the alternative, if a reversal is not granted, at the very least, it's an abuse of discretion for the trial court to simply refuse to take any evidence.
I want to get back to that refuse to take. First of all, were you the trial lawyer as well?
I was not, Your Honor.
Okay. Did the trial lawyer make any kind of professional statement? Because I know what it's like when a judge says, no, we're not making a record. Well, then how do you make a record that they won't make a record? That's tough. I get that. But to use the word refuse is pretty strong, to say that a court refused. Like Justice McDonald was getting to, where is the evidence of a true refusal by the court? Other than, I understand the motion states it, but where is
And I understand that the trial court was not an easy position here. I mean, you're sitting at order hour. It's the 11th hour. Mr. Hoosman's going to lose his home that day, and is there, trying to get the default set aside so he doesn't lose his home. And I would imagine that the trial court a lot of things happen in order hour, and there's nothing that the trial court can do. All I can say to that, Your Honor, is that Mr. Hoosman showed up in court. He personally appeared with his attorney with medical evidence. I think that is reflected in the record, that he did appear with the evidence and was prepared to testify. And, as you stated, Your Honor, it's a difficult position when, he would not have appeared personally with evidence if he wasn't prepared to present it. And so, I'm not sure what else he could have done to make a record in this situation. My client is precisely the type of person that 447.7 is intended to protect. If you look at the 2013 competency evaluation, a licensed psychologist found that Mr. Hoosman cannot maintain concentration. He was unable to follow simple instructions. He could not retain basic information. And the examiner also noted that he struggled to remember the names and ages of his children. He couldn't remember 3 unrelated words after a 5-minute delay. And the examiner concluded that his capacity to participate in the legal process was so impaired that he was incapable of presenting an effective defense at trial in the criminal case. Now, in order to be affirmed, the trial court's decision in this case must be based on substantial evidence, and Iowa courts favor a trial on the merits. Iowa Rule of Civil Procedure 1.977 sets out 5 grounds that may constitute good cause for a motion to set aside: mistake, inadvertence, surprise, excusable neglect, or unavoidable casualty. In the Central Insurance Company of Omaha case, the Iowa Supreme Court set out a 3-factor test to evaluate excusable neglect. Factor 1, did the defaulting party intend to defend? Factor 2, does the defaulting party assert a claim or defense in good faith? And factor 3, did the defaulting party willfully defy the rules of civil procedure, or was the default simply the result of a mistake? Now, the Court of Appeals found that there was no, in evaluating factor 1, the Court of Appeals found that there was no explanation in the record for Mr. Hoosman's failure to respond. And though the record is very minimal, the fact is that statement is simply not accurate. Mr. Hoosman did assert that his failure to respond was due to a disability and that he'd been adjudged incompetent in 2 criminal cases. He cites both of those cases in the motion. With respect to the second factor, the Court of Appeals found that Mr. Hoosman could have filed a counterclaim and would have had the right to redeem, but that he did not have that defense available to him since a counterclaim was not timely filed. Now, this is the Court of Appeals interpretation of 447.7 is an extraordinarily harsh interpretation of that statute. Under the Court of Appeals reading of the statute, no litigant claiming an extended redemption period would ever prevail on a motion to set aside. And again, we're talking about litigants that would be asserting this that are among the most vulnerable.
I
homeowners.
share your concern with that reading of 447.7. It strikes me, it just says you can file a counterclaim. There isn't a deadline for filing a counterclaim. So if he is allowed to contest the case on the merits, he can go in and file a counterclaim, and then the court can decide whether he has a disability and is entitled to the extended period or not. So I share that concern. I am a little bit more interested in the standard of review. I mean, it is abuse of discretion, isn't it?
Yes, Your Honor, it is an abuse of discretion. But I would say that we need to look at the context of this case. And if the court considers that a trial is preferred on the merits in these types of cases. Number one. Number two, the property interest involved. Mr. Hoosman is losing his home, the most sacred property interest. Number three, it's a tax sale context, which is inherently inequitable. I mean, and you look at this case, he's losing his home over $220 in unpaid property taxes, which, if he's granted the relief he's seeking, the plaintiff will still receive their investment back with ample interest. But he's losing his home over only $220. And then finally, given the fact that he's someone with profound disabilities that has special protections under the statute, for all those reasons, he's asserting that. He didn't simply say, I'm a person with a disability. He cited to 2 criminal cases. He was prepared to present evidence, and he was never afforded that opportunity. And I believe that was an abuse of discretion. The trial court doesn't have an obligation.
You may wrap up if you would. Thank you.
Thank you, Your Honor. For these reasons, we ask that the court reverse and that Mr. Hoosman have an opportunity to present a counterclaim pursuant to 447.7. Thank you.
Thank you, Mr. Schmidt. Mr. Augustine? We can't hear you.
I apologize for that.
There
Your
you
Honor.
go. Thank you.
May it please the court. I'm a little bit, I'm not Mr. Technology here, but I'll do my best here. The nature of this proceeding is an action to set aside a default judgment on my client's action pursuant to Chapter 646 for recovery of real property. So the nature of the action isn't to get to the merits of the tax sale deed itself, but merely we've got a tax sale deed. Under Chapter 448, that's presumed to be valid. The merits of that tax sale deed are not at issue here. If we presume that tax sale deed is valid, my client would be entitled to possession. The nature of this action, of course, is an action to set aside the court's ruling that, based on that tax sale deed, my client is entitled to possession. It is the case that this court must find an abuse of discretion if it were to set aside the trial court's judgment. This court has held in the past and other cases that the trial court's findings have tremendous weight. That evidence must be viewed in the light most favorable to the trial court, and the trial court's decision will be upheld even in instances where there are no explicit findings of fact. It is the case, and this court has made it clear, that it does prefer a trial on the merits, but that doesn't diminish the fact that there are requirements that must be followed before the appellate court will set aside the trial court's judgment. And that would include
Mr. Augustine, this is Justice McDonald.
Yes,
Can I
Your
ask
Honor.
you a question about that?
Yes.
So you said the district court's findings are entitled to great weight. We're at substantial evidence review. In the sentencing context, right, we say that the district court actually has to make some findings for us to review. And as I look at the district court's order here, we really don't have any explanation for why the district court did what it did. So, I guess this kind of cuts both ways in some sense, but, how can we review the basis for the district court's decision when there are absolutely no findings for us to look at?
Your Honor, if I may, Your Honor, I was at that hearing. It was an order hour hearing, and I think part of the limitation was the nature of the hearing. It was not, there was no court reporter available at the hearing. Mr. Hoosman was there in attendance and did have the opportunity to provide evidence, and so did his counsel. And in fact, she did provide evidence. We also provided evidence, and the court made a determination based upon the evidence that was provided.
What evidence was provided?
Mostly, my recollection, Your Honor, was there was a motion that was actually filed that precipitated the hearing, and the majority of the appellant's case was based upon the contents of that motion, which are a matter of record. I do not recall that the psychologist report from 2013 being offered or certainly not introduced until after the hearing in the form of a motion to enlarge, with regard to which the court
But
didn't.
when you say other evidence, was there testimony or were there exhibits presented?
I don't recall Mr. Hoosman ever testifying because he just didn't testify. It was his choice not to testify, Your Honor. That's my recollection.
Was there any effort to present testimony or to present exhibits?
I don't recall that being the case. I think it was based entirely on the motion, Your Honor.
I'd like to know if you're, since you were the trial attorney, was he denied the opportunity or did it just not get to that point? Because Mr. Schmidt said denied the
It was not
opportunity.
denied. Your Honor, my recollection is that it did not get to the point. He simply didn't testify. If I may continue, so again, I certainly can understand and appreciate that, you know, as a rule of protocol, we prefer a trial on the merits. Certainly that's reasonable, but it does not eliminate the requirements that we still have to show good cause, or in this case, as the appellant would have us consider, that he was entitled to defense by a guardian ad litem. In either case, however, there must be a finding by this court that the trial court abused its discretion in failing to so rule.
Here's where I'm coming from, Mr. Augustine. We sort of have this 3-element test from that 1994 case, whatever it is. Well, Brandenburg and then Central National before it. And the 3 elements are acting promptly, which I think he did. The motion to set aside the default judgment was filed about 3 weeks after the judgment was entered. Good faith showing of a defense, which I think there was at least a good faith showing that there's a potential defense. And then no showing that he willfully ignored or defied the rules of procedure. And that seems to be tied up with the second element. But it does appear here that that Mr. Hoosman just didn't understand what was going on. It wasn't that he ignored or defied the rules of procedure. If you know what legal aid says is correct. So given that, I mean, what's the big deal about setting aside the default judgment and allowing this matter to be resolved on the merits?
If I may respond to that, Your Honor. Okay,
Please.
Mr. Hoosman was, first of all, he was given notice of the tax sale prior to the tax sale by publication and by mail. Okay, property was sold at tax sale. About 2 years later, he was given notice of expiration of his right of redemption by both regular and certified mail. He failed to respond in either instance and a tax deed was issued. Thereafter, my client filed in January of 2019 an action for recovery of real property. Mr. Hoosman was served by personal service with a copy of the original notice and the petition. He didn't respond. Thereafter, he was given notice of intent to seek written application for default pursuant to Rule 1.972. He failed to respond. It was only after the court's ruling that and execution on the writ of possession was imminent that he then responded. And he testified, or I'm sorry, the material that has been submitted to the court makes it clear that he has been trying to defend himself on this matter for several months. The record reflects that. He also had indicated that he previously had tried to get a tax abatement. So we have a situation where Mr. Hoosman knew there was a problem, and yet he did nothing about it. And I don't think that, Your Honor, with all due respect, that reflects an intent to defend, or I think it may reflect the opposite, and it suggests that he willfully ignored the rules of civil procedure.
Well, I mean, it shows he didn't want to lose his home.
And I'm not arguing he didn't want to lose his home, Your Honor, but I don't think that is the test. I think the test is, okay, fine, you don't want to lose your home, but there still are rules of civil procedure that apply and must apply to everybody in order to have an orderly justice system. He he disregarded those rules, I believe.
Mr. Augustine, does it matter that he had a colorable claim to be disabled, right? I mean, so kind of your argument is he didn't do enough, but his whole point is, I really didn't do enough because of my disability. And the
Your Honor, I
law
don't-
has special protections for those who are disabled and unable to defend. Please answer that.
Okay, Your Honor, I don't believe that he did have a valid claim, okay, because he is relying, it is correct that Mr. Schmidt says he's relying on section 447.7 as the basis for his meritorious defense. The general rule is that a person under a legal disability that they have a period of 1 year following the removal of that legal disability in which to redeem from a tax sale, even despite the prior issuance of a tax sale deed. That's correct. However, there's an exception to that rule. In the case of a situation where the tax title claimant has filed an action for recovery of real property, the person claiming the legal disability has to either file a counterclaim within that action on a timely basis, or they have to file a separate action to redeem within 30 days after service of notice of the original notice. For us, perhaps that's what the legislature had written. And, perhaps the legislature could have written the statute differently, but it didn't. But what Mr. Hoosman would like to have us do is rewrite that statute to say that it's unreasonable because it didn't give him enough time. Again, for us to rule otherwise would be to essentially disregard the statute. And it would essentially render tax titles as a whole unreliable and unmarketable. Further, it would render the tax sale system certainly not as capable at securing unpaid taxes for treasurers because of the uncertainty with tax titles. So I don't believe, Your Honor, that he does have a meritorious defense, certainly not under 447.7. Perhaps he should
I guess
have
I don't
considered
follow the
proceeding-
argument that this would make collections unfeasible. I mean, if hypothetically Mr. Hoosman had just gotten to legal aid a few weeks earlier, he would have answered the action and filed the counterclaim.
That's
So-
true, Your Honor.
And
That's true, Your
so, and then there would have been a determination of it on the merits, notwithstanding everything that happened before. So, again, if this had been a commercial case and somebody moved to set aside a default judgment 3 weeks after it was later and said, I didn't realize what was going on, I have a good faith defense, I'd like to litigate on the merits, I'm not sure we would say it was that big a deal, would we?
Well, again, I think to answer your first question, had he come earlier, had he done something earlier, had he responded prior to the entry of the judgment? Yes, correct. But the case is here, if we are to say that he has a meritorious defense under section 447.7, we have to say also that the statute is not correct. The statute was not properly written. It offers a remedy for somebody under legal disability. He does not qualify for that. Not only because the evidence doesn't show he was under legal disability, but because even if he were under legal disability, he has missed the timelines that the legislature set forth.
Hey, can you explain that to me, Mr. Augustine? I guess I don't understand. If the default is set aside and the case is still pending, can't he assert the counterclaim in the pending case?
Yeah, if that's correct. If
So
we
he
set it
hasn't.
aside, I would
I mean-
assume he could file a counterclaim within that action.
Right. So, I mean, we're not ignoring the legislature. I mean, he wouldn't be able to file some sort of independent action as the statute provides, because maybe that timeline is passed. But he would certainly be entitled to file a counterclaim in the pending suit for the writ of removal, right?
He could file that, providing again that he qualifies under that statute, and certainly, Your Honor, there's no evidence that he does. The only evidence is a psychological or psychologist report from over 7 years ago, Your Honor.
I want to, first of all, would you agree with Mr. Schmidt that this statute is geared towards people? Let's assume he would qualify had there been a hearing. Let's assume he would have qualified. Doesn't it make sense that he'd be tripping up perhaps all over the place and maybe not get to legal aid until the die is cast? Doesn't that kind of seem exactly the scenario that this statute is geared to protect?
Certainly, the statute is geared to protect those who have an insufficient ability, Your Honor, to protect themselves. There's no question about that, and I respect that. But the evidence here reflects the opposite. Again, the evidence has reflected that he apparently said in his own words that he's been trying to work on this for months, and that he had gone before the county in order to have an abatement of taxes. So it's not
Well,
the case.
obviously he was working on it for months, but not very successfully, or he wouldn't have been in the situation he was in. So doesn't that kind of go towards, I mean, it sounds to me like he was trying to take the route pro se, and wasn't doing a really bang up job. Would that be a correct summary?
I would argue in my experience, Your Honor, that there are many cases in which somebody doesn't do a bang up job. And because of that, the rules of civil procedure can have what may seem to be a harsh result. But that doesn't mean that we can disregard those rules, Your Honor.
I would agree, especially when you're talking about fellow colleagues in the profession of law, or maybe even some pretty savvy individuals. But we're not talking about just anybody. We're talking about people with a legal disability. That's a pretty strong word. Well, I asked you to assume that in this case. And you're right, we don't, because there was no hearing on the merits.
Okay. For purposes of, I'm sorry, Your Honor, I didn't mean to interrupt you, but for purposes of assumption, I understand that that's what the statute serves to protect, and I appreciate that. But
Counsel, if I could follow up on your concern that this, if we grant the relief requested, this will undermine the marketability of these tax deeds. I mean, can't you still move things along with a default, and then the rules give them what, 60 days from the default judgment? So you're going to, at most, there's just going to be an extra few months, right? I mean, I don't understand how this is going to destroy the tax, deed system.
I guess the best way to explain that would be by example, if I could continue, Your Honor. Let's suppose.
Yes, please go ahead and answer the question.
Let's suppose a tax deed is entered, and an action for recovery of real property is undertaken, a successful action. And let's say then judgment's rendered. A year later, the person who lost the property comes out and says, I was under a legal disability. Okay, we're well beyond 60 days at that point, Your Honor. And under the statute, perhaps they could argue that, or shortly, maybe shy of a year, an argument could be made that I was under a legal disability and therefore entitled to protection under Rule 1.977, and the judgment should be set aside, or I was entitled to defense by a guardian ad litem. People who rely on the law, people who acquired an interest in that tax title, how marketable is that? If there's the possibility that somebody could later on claim a legal disability.
You may wrap up.
Your Honor, we would just ask that the court uphold the trial court's ruling on the basis of Mr. Hoosman not providing sufficient evidence that he was under a legal disability and certainly not entitled to a guardian ad litem based on the evidence, and also not entitled to the protections of Rule of Section 447.7, and further on the basis that the court did not abuse its discretion in affirming the order and setting aside, or at least overruling counsel's motion for reconsideration. Thank you, Your Honor.
Thank you. And Mr. Schmidt, I'm going to ask you to go straight to that topic we were just leaving. I'd like for you to comment on the discussion we just had about tax titles not being reliable if we would allow something like this.
Thank you, Your Honor. I mean, essentially what Mr. Augustine is requesting, which is that this court adopt the position taken by the Court of Appeals. What he's requesting is that no person with a legal disability asserting a counterclaim under 447.7 can ever move to set aside, because the counterclaim will never be timely. Mr. Hoosman is not asking for any extraordinary procedural right here. Anytime in the real estate context that there's a foreclosure action, someone, by default, a litigant could file a motion to set aside or a petition to vacate. So essentially Mr. Hoosman saying, well, in this context, for someone with a legal disability, this should be interpreted more narrowly than you would in a foreclosure context. And it takes a very long time from the time of the tax sale to the time when the purchaser of the tax sale actually acquires the property. So in this case, what was really the prejudice to the plaintiff in this case? Had there been an evidentiary hearing, they would have been paid in the end with interest. So I would reject the argument that this in some ways would make this instrument unattractive when the plaintiff will be paid in full if the counterclaim is granted and Mr. Hoosman redeems.
Mr. Schmidt, I take it you can't shed on any light on Mr. Augustine maintains that, and he was at the hearing, that there was no effort to introduce exhibits or testimony or medical evidence made on behalf of Mr. Hoosman. That's not your understanding, but you weren't there, right?
That's right, Your Honor. I was not involved in this case at that time, but and I understand that the Supreme Court is in the position of trying to figure out what happened here because the record is so minimal. But I think that is central to our argument, which is that Mr. Hoosman tried to make a record and was prepared to make a record, and the trial court would not make a record. I wasn't there, but I don't
Mr.
think.
Schmidt, I guess I want to push back on that a little bit because you keep saying he tried. I mean, you've told us you were not there. And you said he tried to make a record. He was prepared to offer testimony. Mr. Augustine said he was there. And that's not his recollection of what happened. So let me kind of tell you my thought on this and where I'm really struggling with your case, and then you can try to overcome it. So to me, this is kind of a standard of review case, and it's abuse of discretion. And it's a big deal to say to a district court judge, or for us to find that the district court abused its discretion. That means we're finding it did something clearly unreasonable or clearly untenable. And on this record, if we don't even know what happened at the hearing, and it appears to be disputed between you and Mr. Augustine, how can we say the district court did something clearly unreasonable or clearly untenable? That's my sticking point. So if you'd address that, I would appreciate it.
Thank you, Your Honor. And as the Chief Justice noted, I think it's important to think about the context here and how these cases are going to come to the district court. We're talking about very vulnerable litigants. Mr. Hoosman's case here is based on his incapacity. So in many cases, these are going to come to the court at the last minute. And, in a case here, apparently there wasn't a court reporter available. So, the trial court, may not have been able to immediately make a record, but I think in a case where there's this much smoke, where a litigant's saying, hey, I've been found incompetent to stand trial in 2 criminal cases, and these are injuries that appear to not, he has a brain injury. There's nothing in the record to suggest that this is going to get better. Based on those assertions that are made in the motion to set aside, it seems like he is someone who would be eligible to have the right to redeem in this case.
So could I ask you, Mr. Schmidt, I'm looking at the 1.904 motion. It was filed by attorney Nathan Peters, and he said that Mr. Hoosman's legal counsel attempted to submit medical evidence showing that he had been adjudged incompetent, which I take it was that document that was submitted with the 1904 motion. And he says the court did not admit this document into evidence. Was he the gentleman that was representing Mr. Hoosman at the hearing? Mr. Peters?
And Your Honor, I think I'm over time. Can I respond?
Yes, please do.
Thank you. I believe Attorney Michelle Youngers was representing Mr. Hoosman.
Okay.
Thank you. Would you like to wrap up?
Thank you, Your Honor. And for this, these are very important rights to protect our most vulnerable citizens, and for the reasons that have been discussed, I ask that you reverse the decision and remand so that Mr. Hoosman may assert a counterclaim under 447.7. Thank you.
Thank you. Okay, this hearing is adjourned for No Boundary versus Hoosman. It is taken under advisement at this time and submitted, as well as Rabick versus State of Iowa is also submitted without oral argument. Bailiff, you may close court for the morning.
Hear ye. The Honorable Supreme Court of the State of Iowa is now adjourned.